Okay, Steve Clark versus Twinsburg. Each party will have 15 minutes to present an argument. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve for rebuttal, counsel?
I would like to reserve 5 minutes.
All right. I'll try to let you know when you're down to about a minute of time. If you look over there, you'll notice that top one is counting down from 15. So when it gets to 5, it'll be into your rebuttal time.
Okay.
That one, just in case that would occasionally confuse folks. The arguments are being recorded. So when you come to the podium, please introduce yourself. Please stay behind the podium so we can hear you well and visually record you. If you want that to be part of the visual recording, you might want to move it close to the podium. That's up to you, Mr. Mendenhall, because I'm sure that won't be picked up over there as we sit here. So we will see it adequately. The people later on the video may not know what you're referring to.
Okay, thank you.
I don't know that it's going to apply in this case, but if you would have the name of any child, minor, or victim or anyone, please refer to them by initials or some other commentary like in the morning in every case, just in case. With that, we read your brief. All right, proceed whenever you want.
Yes, thank you, Your Honors. May it please the Court, my name is Warner Mendenhall, and I represent Lynn Clark, who is here today, the appellant. This is a project involving 2 speculative warehouses. The first one has 300,000 square feet in it, and the other has 150,000 square feet. And the problem that arose in the process of approvals for the developer is that Twinsburg is a very special place. It has had a long history of environmental activism. It has some real checks and balances on what gets developed in the city. And initially, the city requires what's called an environmental impact assessment, and that assessment lacked mandatory sections on social resource impacts and qualified revenue impacts. That's under Ordinance 117505. They're simply not in the record. The ordinance states that the purpose of these environmental standards is to recognize and quantify these impacts, to eliminate projects resulting in net revenue losses to the community where no redeeming public benefits are provided. So without those required sections, council can't do its analysis and cannot fulfill its job to review the proper plans. In the record, you will see that these sections were promised to the city, quote unquote, under separate cover, but they never have been as far as I can see. The section of our brief that covers that is on page 8, our initial appellate brief. Those required assessments would show whether the public interest of the development outweighed any environmental costs. And the city in its briefing argues that this information was implicitly considered through other documents and general development goals, but it's not allowed to implicitly consider it. It's a requirement to have these in the record. The broad interpretation that the city wants the court to adopt, and the lower court did adopt, essentially nullifies these specific performance requirements in the ordinance. And it renders the balancing requirement of these economic standards essentially meaningless. I think this reason alone is enough to overturn the lower court decision because it undermined the decision-making process. It deprived council of critical information needed to assess those words, those key words, overriding public interest that would justify these environmental impacts. By approving the project without this analysis, council operated in an arbitrary way. The lower court dismissed this as a simple procedural defect. We consider it a key procedural violation. The second thing that happened, which is more of a substantive violation.
Counsel, can I just ask you, when did you raise this issue?
We did not raise the issue before the council. It's almost like if I'm going to give an analogy. If I apply for a passport and I don't have my birth certificate, I don't get the passport. They applied to get these plans approved, and they completely lack these 2 key requirements required by the ordinance. The lower court says because that wasn't raised, it's waived, and that, I think, is just not true. The second thing is they altered natural water courses. Twinsburg is replete with natural water courses throughout the city, and there was really a lot of citizen concern about those 24 years ago when they passed these requirements. But you can't also alter natural water courses without demonstrating an overriding public interest. The Project Gobo site plan would alter 1,038 linear feet of 1,685 linear feet of streams. This is a fact that's undisputed in the record. This conflicts with Ordinance 117503, which says, natural water courses shall not be filled, dredged, cleared, deepened, straightened, stabilized, or otherwise altered, except in cases of overriding public interest. Again, that wording comes up. Council, in its rulings and its findings, failed to explicitly state an overriding public interest to justify this alteration. Again, we have a fundamental failure to apply the ordinance's clear requirements. The phrase overriding public interest suggests the public benefit must be substantial and clearly articulated that it outweighs the environmental costs. The other thing about this, and I think I mentioned this before, these are speculative sites. Because it's speculative, there's really no way to establish the social resource impacts or quantified revenue impacts that are required. They don't know, council did not know the number and quality of jobs created, the potential tax revenue for the city, or even the environmental impacts of whatever operation the business would engage in. They did do a traffic study, but without knowing what the business was, what the jobs were, and what the potential traffic from that specific type of business, that traffic study is basically not too relevant. The city argues that requiring this level of specificity would hinder the development, and that's actually true. The whole idea is to hinder the development, to make sure the overriding public interest is considered. The city seems to think that any economic development is an overriding public interest, but that would really, again, nullify the environmental impact requirements of the ordinances. I think that the correct interpretation of overriding public interest should require concrete, quantifiable evidence of significant public benefits, such as actual jobs, actual tax revenues, a clear demonstration that these benefits outweigh the environmental costs, and an explanation of why the benefits can't be achieved through a less environmentally destructive means. Again, the lower court deferred to the city's judgment on this matter. The lower court really did not clearly show any overriding public interest or address that issue. And I understand that most courts in zoning and this type of regulation defer to the local bodies, but the citizens of Twinsburg passed these special regulations. And without this finding of overriding public interest that is specific, this plan should have been rejected. The other thing that they did was the wetland mitigation. The site plan affects 0.68 of 0.75 acres of wetland, almost 90%. This is a significant change to the local environment. To mitigate this loss, this applicant went and bought wetland mitigation credits from other locations around the state. That may satisfy federal and state requirements for wetland mitigation, but it doesn't deal with the local requirements. Twinsburg Ordinance 117505 says, where significant features have been identified in the environmental assessment process, or where mitigation measures have been recommended, efforts should be made to preserve features and comply with mitigation measures by incorporating them in the open space part of the development. So Twinsburg's saying, you can't go out of our area and mitigate. You have to mitigate on site. You have to create and build in a way that respects those environmental demands. The other thing that happened is there was an inconsistency in the approved plan, and that's why I have this exhibit here. And I mentioned this is out of Part F on the left and Part J on the right. And what I want to point out is in Part J, that's what was submitted and approved by the Army Corps of Engineers. What was actually passed by council in June of '22 was on the left, under section F of the exhibits. The problem with this is,
And you're about a minute left in your initial time.
thank you. I may run over just a minute, because I do want to get
If
through
we
my-
do, well, that's fine, if you just come off your button.
Okay. That violates ordinance 117503A12, which requires that these permits actually be applied for and be presented to the council before approval. The permit for the picture on the left, that has never been issued by the Army Corps of Engineers. In the record, there's an Ohio EPA email that says it's our understanding that the developer has approached the Corps, meaning the Army Corps, about additional permitting that would be required to further impact wetlands and streams. So clearly, the Army Corps hadn't approved it, the Ohio EPA hadn't approved it, and they could not present approvals to the council in order to get this passed. The lower court erred again by not recognizing the importance of having all necessary approvals in place before granting final approval, and this exposes the city to environmental risks it wanted to avoid and legal challenges that its ordinances were designed to prevent. I noticed generally through the appellee's briefs, and even in the lower court, they really emphasize these approvals by the Army Corps, the Ohio EPA, U.S. Fish and Wildlife. Of course, there was never an approval by Summit County Soil and Water. But again, I kind of want to close with this. Twinsburg's environmental performance standards impose locally determined requirements beyond what these federal, state, and county agencies require. And these local standards, as we've mentioned, are designed to protect the unique environmental character of the city. Twinsburg's slogan is naturally beautiful. I think it's naturally beautiful Ohio. That encapsulates the history and policies of the citizens, longstanding commitment to preserve its natural heritage. These, again, like I said at the beginning, were passed in 2000, and they were specifically designed to protect the natural beauty of the city. Approving Project Gumbo without proper analysis and adherence to these standards undermines the environmental stewardship that this community has engaged in for the last 25 years. And it sets a precedent that erodes both Twinsburg's ordinances and its character as a city. The lower court did not consider how its decision plays into this broader context that's been around for 2 decades. And I'll reserve the remainder of my time for rebuttal. Thank you, Your Honors.
Thank you.
Good morning, Your Honors. Judge Stevenson, Judge Hensel, Judge Sutton. My name is Eric Sugarman, and I represent the city of Twinsburg in this matter. With me at the council table is my colleague, Lisa Summers. I almost don't know where to begin because my esteemed opposing counsel conflates so many issues in the record that again, it's difficult to even know where to start. But where I think I'm going to start is with the extensive review process that was conducted by the city of Twinsburg. And while I certainly appreciate these aspirational statements that he made about environmentally conscious people, those are decisions that are ultimately made by the local government. The local government, the administrative agency, and this is an administrative appeal, are charged with making decisions that are in the best interest of their own community. And that's exactly what was done here. And there was extensive evidence in the record to support this. Appellant minimizes the review process that was undertaken, and I want to go over that a little bit before we start. First of all, this matter under the Twinsburg ordinances starts with site plan review by the Twinsburg Planning Commission. Planning Commission actually held 3 separate hearings about this site plan. This wasn't a half-an-hour meeting where they rubber stamped a plan that came in and said, hey, this looks great. There were 3 separate public hearings. There were reports that appellant's counsel referred to, but instead of minimizing them, I think it's important to understand exactly which agencies commented on this particular plan. The federal review of this plan was conducted by the U.S. Army Corps of Engineers and the U.S. Fish and Wildlife Agency. The Ohio EPA also issued a report and recommendation. There were 2 reports issued by Summit County agencies, the Summit County Engineer and the Summit Soil and Water Conservation District. And Twinsburg itself conducted internal investigations, if you will, or analyses by their fire, their engineering, and their planning departments. The record that was filed in the court below was extensive, and you'll see how many different reports and other exhibits were introduced before the trial court and indeed before Planning Commission and City Council. When an appellant received an adverse ruling, or stated in the positive, when this site plan was approved, they filed a 2506 appeal in the Court of Common Pleas. The record was filed, and as you'll see from the trial court's opinion, which was very well reasoned, what appellant doesn't really talk about is a standard of review that is supposed to be utilized by the trial court. And I'll get into a minute the standard of review that you as the Court of Appeals goes into. It's, let me go here for a second. The appellant in its corrected brief states as follows: Twinsburg Council must weigh the site plan public benefits against the environmental degradation that it will cause. There's a weighing process that must take place, not only before the Planning Commission and Council, but before the trial court. It's not up to this court to weigh the evidence. Again, as I started by saying, the evidence needs to be heard and determined and weighed by the administrative agency. This court has a very limited appellate capacity. And I know that Judge Stevenson wrote an opinion in late 2020 that recognizes that an appellate's court's review process is designed to affirm those decisions. As the Court of Common Pleas is not designed to act as a super board of zoning appeals or a super city council, this court is not designed to be a super reviewer of the underlying facts that take place at the local agency. I want to talk a little bit about the evidence that was discussed regarding the economic benefit and the environmental degradation, and I'll start with the latter first. All of these agencies, every single one of these agencies that I talked about before, made the determination that the mitigation that was proposed by the applicant fully mitigated all of the potential environmental degradation that was going to take place on this site. As with any site, whether it's residential, commercial, or industrial, there is going to be, or likely to be, some environmental degradation that's going to occur. That's why there's mitigation processes in place. And those mitigation processes are developed by the Army Corps of Engineers, by the Ohio EPA, and by the local agencies. There is not a process here that needs to be permitted right now because the building hasn't started at this point in time. But when the permits are going to be issued is when all the plans, the final plans and specifications are going to be issued. And at that point in time, all of these agencies review not only the plans, but the construction processes to make sure that they are done correctly. The streams here, this was not the Cuyahoga River running through this property. This is industrially zoned property that has been zoned like that for many years. The warehouses that are planned for this are permitted uses on that industrial property. It has been vacant for quite some period of time. When these buildings are built, they are indeed speculative. But there's nothing wrong with building a spec building. There were no tenants and there are no tenants that are currently signed up for that. But
as far as the water courses, and you all seem to suggest that the vast majority of the water courses of the wetlands are now going to not be wetlands under this plan, but they bought these wetlands in other areas to mitigate that. Do you agree that mitigation has to be on site? And in your view, is there adequate mitigation on site on the record at this point in time? Or do you say that the mitigation part is purchasing wetlands somewhere else in the area where the state lies?
It probably comes as no surprise that I disagree with Mr. Mendenhall's interpretation of that. The state and the federal government permit mitigation to take place at mitigation banks. There's one over in Copley, the Pansters have had one for many years. And the applicant in the city of Twinsburg specifically followed the rules and regulations of the federal government and the state government in terms of whether or not mitigation.
And Twinsburg has no specific rule or regulation different than the federal or state government?
Not that I'm aware of, Your Honor, and nor has it been cited in the brief that there's any specific regulation contrary to that. So there's nothing wrong, there's nothing nefarious with having environmental mitigation follow the rules of the United States Army Corps of Engineers and the Ohio EPA. There's absolutely nothing wrong with that. And to add to your comment, Judge Stevenson, the streams that they're talking about are ephemeral streams and intermittent streams. They're not rivers, they're not long-standing streams. These take place when there's a lot of rain. And so they are like in any type of an industrial development or commercial development, a lot of times you're going to have to mitigate the wetlands, or else there won't be places to build. And we certainly disagree with appellant's characterization that there was no determination that there would be a public benefit to this. So when there's no tenant for a building, whether it's an industrial warehouse or whether it's a commercial building, we know that a developer is going to expect a return on his or her investment. In this case, there's going to be a substantial amount of money invested in these warehouses. In order to get a return on this investment, the developer is going to need tenants. And in order for those tenants to pay their rent to the developer, they're going to need jobs. And those jobs are going to create tax revenue. And when the city planning department, when the city administration, when the city council takes into account the fact that there is potential substantial revenue from a substantial building like this, they're well within their power. They are well within their power to have decided that there is going to be an economic benefit that outweighs the environmental degradation.
And that kind of touches on and I might not have the term right under the code, the qualified revenue statement and the social resource impact requirements of the environmental statement. In this case, do you dispute that those were included in the statements made or what was given to the panel, or do you say that they weren't raised before, so they can't be raised now? What's your position regarding those statements?
Two separate questions. The first one, I don't dispute that they were not supplemented into the EIA. That was a 282-page document, and they didn't supplement it with those certain paragraphs. But there was certainly extensive information elsewhere in the record as to the potential economic benefits to the city of Twinsburg. Of course there's going to be increased real estate taxes. Of course there's going to be income, okay? And the finding that there's very little environmental degradation to this site. And where's that in the record? That's from all these different agencies reviewed. And again, the planning department made recommendations both to the planning commission and the council about exactly what the economic benefit would be. They are positing an impossible standard here when they talk about the quantified economic benefit. Nobody can really say exactly. Well, there are occasions where somebody could possibly say how many jobs are there. But as a matter of practicality, when you're developing warehouses, when you're developing office buildings, there is some degree of risk, if you will, that's going to be there. And as I said, the developers aren't going to accept that risk unless they're pretty sure that there are going to be a quantified economic benefit that outweighs the economic degradation. Your second question was,
Basically, did they waive that by not presenting it as?
absolutely, that's what Judge Sutton asked before. Absolutely, they failed to do that. And we've cited a case in our brief, I believe it was Tipton versus Walls. Apparently, certainly knew how to raise an issue since he was the one who raised the issue with the building's proposed height being too high. That means he waived his ability to raise this issue before this court.
Thank you.
That's all I have this morning. I believe that the record is complete with evidence to substantiate the trial court's determination. It was, again, a very well-reasoned and thoughtful decision. The trial judge found that on the whole record, and that's an important phrase in this case, on the whole record, there was substantial evidence presented to uphold the city council's decision. With that, I thank you this morning.
Thank you. Back to the waiver argument, it is interesting, if you look at the record and the citizen participation in the record, I would say that it wasn't explicitly raised by the citizens who testified before the record, but they certainly raised concern about environmental impacts and the need to balance the economic benefits with the environmental impacts. These citizens didn't know exactly what the statute said or exactly what to do. But his argument would say, this waiver argument would shield the administrative body from judicial review when they don't adhere to ordinances. I find it very interesting. These are required submissions. What's the social resource impact and what's the quantified revenue impact? And we just heard the admission they were never presented to the council. So they simply weren't presented. So that's the abuse of discretion at the lower court. It needed to consider what the ordinance required and make sure that that was met in the record. It doesn't matter whether this record is 1,000 pages long or 1,000,000 pages long. If it doesn't have those two items, it's not a sufficient record. We're not asking this court to weigh evidence, by the way. The evidence in this case that we're arguing about is undisputed evidence. It's undisputed that streams will be impacted. And if you look on the right, that plan has enough open space, and those streams are still substantial streams on that plan. Only 250 feet was disturbed. On the one on the left, which went before council, those streams are pretty much gone, 90% gone. So that, on the right, you see something that tried to adhere to the idea that you would mitigate on site, not off site. And this idea that a city can say, look, we don't allow speculative buildings, that's what Twinsburg has said here. We don't allow speculative buildings to be built. If you're going to bring in a 300,000 square foot warehouse and a 150,000 square foot warehouse, you need to tell us what you're going to be doing in there first. Once we know that, once we know the impact on traffic and tax revenue, once we know what our income streams are going to be, then we can make a decision that balances that out. So that is true. Speculative buildings are not allowed like this with no economic analysis. And you cannot tell me that a developer could not have an economist come in and make projections based on what would go in that building. Yeah, again, I think his argument was exactly what I said it was going to be. They're relying on the other agencies. Everything that happened with the other agencies, that does not matter. What matters here is what the city of Twinsburg requires for development. And it is very different for very different reasons than many other communities. And it's because of the history of this community protecting its environment. Thank you.
Thank you. The court will take the matter of advisement and will issue a decision in due course. When that decision reads, will be mailed to you by the clerk of court and also be posted in the highest Supreme Court website. With that, I want to thank both of you for your presentation today and your research.
Thank you.